afternoon, everyone. It's lovely to be spending this Wednesday afternoon with you guys. I said earlier that it's not often that I get to chair such a esteemed panel of panelists. It makes my life very, very easy, and I'm very privileged to be sitting with these gentlemen. You would see that, Duncan, if you could also just pop on. We are just waiting for Azhar Bham. He did send me a message to say that it will be 1 minute. I'm sure 1 minute is 1 minute, and he will be joining us. But I accept that my panel actually needs absolutely no introduction. Colin Strime, I did not even ask for his bio, because I think it's as long as my arm, and it's going to take us the entire hour if I need to introduce and tell you all about him. He needs absolutely no introduction. Colin, thank you very much for joining. Colin was absolutely integral, can I say, a founding member, one of the founding members in this AFSA and SARIPA forum initiative. So everything and anything that anyone wants to know, there will certainly be time at the end of the webinar for lots of questions and answers, which you can certainly address to Colin or to the rest of the panel, and we are very, very happy to do so. Azhar Bham has just joined us, and I do apologize, Azhar. I see your name is also Lizelle. Guys, you are not seeing double, I promise. Azhar is a lot. He will, it's Azhar Bham. You guys know him by now. You don't need his name at the bottom to identify him. Azhar Bham, I earlier looked, and I won't say when he joined the bar, because I might just show my own inexperience and give away his age. But what I can say is that Azhar is officially next year. Azhar, you will be practicing as a senior counsel for 20 years. That's remarkable. It's incredible. Azhar is also the chair of the AFSA construction division, and also an absolute integral part of this SARIPA and AFSA initiative. Duncan Turner is also one of my colleagues, mine and Azhar's colleagues. It's an absolute honor to have you, Duncan. Duncan is the chair of the mediation division of AFSA. And I, for one, is looking really forward to hear what Duncan has to say. I think mediation is probably the most unutilized tool in business rescue. And although there is specifically provision made in the rules that Colin will also talk us through during the webinar, to see where every one of us can benefit and learn from Duncan with his vast expertise in mediation. That being my panel, without absolutely no further ado, I think it's appropriate, Azhar, if you could give us an overview and tell us about the idea, everyone, if I can just say, is to give you an idea, a little bit of a background as to, again, but you guys are well aware of the AFSA and SARIPA initiative. But in practice, what are we seeing already? Where do we think that, in particular, our BRPs and other stakeholders can benefit from this? And then hopefully to give you some practical guidance of how to get this any dispute in a BR scenario on the road, and rather on the roll, to get it to resolution. Azhar, if you could maybe just tell us a little bit about the arbitration side of it, we would be indebted to you. Thank you.
Thank you very much. Can I start off by just talking a little bit about the development over the years of the sphere of business rescue, and how we got to the point that we did get to. So the Companies Act, which introduced the new Companies Act, which introduced business rescue, was enacted in 2008. In it came a chapter 6 dealing with business rescue, came in with a lot of fanfare, unfortunately not well written, and with a number of gaps, one of which was in the sphere of dispute resolution, particularly having regard to the purpose underpinning business rescue. Now, I start off at that point because when it was originally introduced, it was introduced so as to achieve one of two purposes. The one and primary purpose was to try and save an ailing company so that it could return back into the economy as a healthy company. That would save jobs, that would keep it in the economy, and that would avoid a failure where one could be avoided. And of course, it introduced and put into place various mechanisms to try to achieve that. I need not discuss all of those mechanisms because the focus of today's discussion is slightly different. But the first few years of business rescue substantially was a case of the industry, the courts and lawyers finding their feet around a chapter which was uncomfortably worded. And when I say that, I'm not unkind, because our courts, particularly the SCA, have commented on that from time to time. But the net effect of that was for about 5 or 6 years, most of the cases that went to court revolved around interpretive matters in respect of business rescue. And of course, it went through the traditional court system. It would go to the High Court, and then from the High Court on appeal to the SCA, and the whole process would take, as traditional litigation in that format takes, would take 2 to 3 years. Of course, the negative effect of that, that had to happen because you needed to understand what the chapter meant. The negative effect of that, and something that it showed up, was that the time it took to litigate quite a few of those issues was such that it often undermined the purpose behind business rescue. Now, when I say the purpose behind business rescue, I mentioned that the primary purpose was to try to save an ailing company, a battling company. The secondary purpose was, if that could not be done, to result in a better return than liquidation would yield, better return for creditors, possibly for shareholders, and the like. But the longer it went on, the more that purpose was undermined, because the act was written with a speedy process in mind. Now, of course, we all know that often those who write legislation, there's a big discord between them and what happens in practice, particularly when matters are challenged, and especially when litigation occurs, because that takes a long time. And that problem persisted and very often undermined and destroyed the prospect of business rescue in circumstances where it might otherwise have succeeded. Now, side by side with understanding the act, with the implementation, with the various visits to court, developed an organization called SARIPA, which specialized in this area of the law, brought together practitioners from across the board, whether it was attorneys, whether it was business rescue practitioners, or the like, involved other role players in the industry, and I'll come back to that shortly. And they became the leading industry body dealing with this particular area, promoting it, trying to make it work better, and trying to make it work in a manner which gave effect to the underlying philosophy, particularly of speed, so that it had a chance of succeeding. Over the years, one thing became quite clear, and that was that disputes which arose either prior to the adoption of a business rescue plan or in the implementation of the business rescue plan, which went through the traditional court system because there was no compulsion to arbitration, almost invariably killed off that particular business rescue, particularly in the circumstances where a plan had been adopted, where it needed to be implemented speedily, made provision for speedy implementation, was then stopped in its tracks because of some sort of a dispute or the other. That took 2 or 3 years to resolve, and that was just anathema to the very philosophy of business rescue. With some innovativeness, things started moving into a direction where business rescue practitioners, attorneys, the BRPs themselves, began to realize that what you need to do is find a mechanism which to resolve disputes which matches the underlying philosophy guiding business rescue. And so what began to happen in an ad hoc manner was for dispute resolution mechanisms to be written into the business rescue plan. Now, let's just pause there for the moment. When you talk about the business rescue plan and the adoption of it, the calling of meetings, you're talking of parties with very many different interests, often pulling apart from each other, but ultimately wanting to achieve the same goal. So you'd have the creditors, you'd have employees, you'd have the financiers, pre-commencement financiers, post-commencement financiers. You've had landlords and a range of other interested parties. And they often were operating in a world of their own and would come into dispute without fully appreciating that the manner in which the disputes were resolving was, again, and I say it for the umpteenth time, destructive of the process itself. And of course, when the process was destroyed as a result of a failure to resolve disputes quickly, it meant that everybody lost. So not only the disputing parties, but everybody lost. And so what was written into the business rescue plans was a compulsory method for the resolution of disputes through arbitration, which would be final and binding, and where time limits were set or provision was made for those disputes to be resolved speedily, certainly quicker than your average arbitration, and certainly quicker than the court system, so that it would not hinder the ultimate implementation of the plan itself. And what started off on an ad hoc basis began to grow, and it began to grow simply because it was working, it had benefits, it had advantages, and it assisted in facilitating achieving the end of business rescue. That eventually developed, and that led to collaboration between SARIPA on the one hand, the leading body when it comes to the sphere of business rescue, and AFSA, which we'd like to believe is the leading body in South Africa when it comes to organized, institutionalized arbitration, so that the process could be taken even further. And eventually, the joint venture between AFSA and SARIPA was launched, such that they would together promote arbitration as a means for resolving disputes in the business rescue context. To give effect to that, a number of things was done. The first was that rules were written, and Colin will talk about those rules and how they are directed towards facilitating the process. The second was that a panel was set up. And that panel, as things stand at the moment, comprises of retired judges. Most of them were judges of appeal. Why was that choice made? That choice was made because the sense was that one needed fairly experienced people in the sphere of dispute resolution who would be able to deal with matters fairly quickly, who would have the time to do so, so that issues that arose could be resolved as quickly as possible. And that's what it was directed towards. The third aspect then was to try to promote the inclusion of the AFSA/SARIPA dispute resolution clause and mechanism into business rescue plans so that it becomes the forum of choice, as it had become over the years in many commercial disputes, because those clauses were written, the AFSA dispute resolution clause was written into many a commercial agreement. Now, of course, as things always occur, the manner in which it plays itself out takes a little bit of time. The initiative has been around for a little while, and it's now beginning to yield results. Of late, as Colin will tell you, I think there are 3 significant business rescues where in the plan itself, the clause has found a place, and any disputes that arise in the implementation of those plans will go through the AFSA/SARIPA mechanism. Now, there are a few things that that's quite important to bear in mind. The first is that in order to understand the litigation landscape in the business rescue context, one needs to understand and appreciate, and that's going to be a function of education, the different types of interest groups that operate within a business rescue. I've mentioned them previously. Just to repeat it quickly, you've got the creditors, you've got a specific group of creditors called your primary lenders, you've got the landlords, you've got post-business rescue financiers, you've got employees, and a number of other groups, each of whom has got their distinct interests. And if you're litigating in that sphere, it's important to start understanding the different interests that drive each of those particular groups, because you'll understand the disputes and why they might raise disputes a lot easier. The second aspect would be what I've spoken about earlier, litigating in a manner which is quite different from the manner in which many of us have been used to litigating, where things take a bit of time, but litigating in a manner where you understand that for it to work, you've got to move very quickly from the time of declaration of the dispute to the time of resolution through an award. Duncan will talk about an alternative, but through an award is a short space of time so that the plan can be implemented and be given effect to, and the company can then get back on the road. Now, that's what the collaboration was directed towards. It's written its clause, it's gone out and marketed, it's got its panel that from whom arbitrators will be chosen. And now it's beginning to yield results because it is finding its way into different plans. Of course, the second step that we need to take would be the step of education. And we've spoken about this, and some plans are afoot to start holding specific seminars and workshops in order to deal with matters which practitioners would need to have a feel for when they start litigating in this particular arena, so that they litigate in a manner which is useful to the process as opposed to destructive of the process. And in many senses, litigation in this context has one hallmark. Whichever of the parties you tend to be litigating for has as much an interest as every other party for that dispute to be resolved as soon as possible. Because if it's not, and the plan fails as a result, that party who may be holding up things would be as much a loser as every other party. The plan fails, everybody loses. So unlike traditional litigation, making sure that disputes are resolved in a manner which is speedy and which is catered for by the rules is in the interests of every party. And for that reason, you'll find that it doesn't cater well for parties who want to carry litigation to the death or want to use litigation in order to filibuster resolution of matters because they end up losing themselves. Where are we then at present? As I mentioned earlier, we've got the clause. We are getting that clause written into business rescue, significant business rescue plans at the moment, and I have no doubt that that's going to continue because it's got the two primary parties, one in the sphere of arbitration, the other in the sphere of business rescue, who have jointly embarked on a venture in order to facilitate the process and who are working towards it. The third aspect would be training professionals specifically to understand the imperatives of litigating in a business rescue context, and that's going to be a very important part of making the process itself work. Even though the Companies Act is around for 16 years, there's still many areas of business rescue which are frontier areas, and properly litigating business rescue matters, not fighting about interpretation issues, but fighting about disputes which arise in the context of a business rescue plan, and knowing how to do that is quite important. The third area which is quite important is that is disputes which arise prior to the adoption of a business rescue plan. Remember, at present, it's the business rescue plan and its adoption which makes arbitration compulsory because it's been passed and adopted by the majority of creditors, and our courts have said that is legally effective. That happens after the business rescue plan has been adopted. But there still remains an area where disputes could take a long time and it's not binding, and that is in the period prior to the adoption of a business rescue plan. That would include questions about whether a party is a creditor or not a creditor. That would include matters which may arise in disputes between a particular interest group or a particular party and a business rescue practitioner. These all do occur. And so the next area which would need some attention to try to sell to parties, and this would be the parties who have an interest in business rescue, and I'm talking about the parties I mentioned earlier, your creditors and the like, for them to understand that a quick, speedy mechanism for resolution of disputes in relation to a company in business rescue, even prior to the adoption of a plan, is in their own interests, because if a business rescue plan succeeds, is adopted and is implemented, everybody is placed in a better position than they would be if the business rescue plan or the business rescue process fails and the company goes into liquidation. A properly managed and successful business rescue achieves that purpose, and as a result of it, by comparison to a liquidation, all parties are in a better position. And so much work still needs to be done and I think a lot of work has actually been done by parties like SARIPA to persuade parties and interest groups who are involved in a business rescue to commit to an arbitration process for all the reasons I spoke about earlier, so that it facilitates the period even prior to the adoption of a plan, and it facilitates the quick resolution of disputes before then. That then brings me to my concluding remark. Duncan is going to deal with a separate aspect of it. Colin will talk to the rules. And that is that we are in the early stages still of developing the whole concept of arbitration in the business context. But when I say early stages, we are in those early stages having learned a lot from experience over the 16 years since the adoption of the Act. So it's the early stages underpinned by practical experiences of what could sabotage a business rescue process and what could facilitate it. And we'd like to think, and I think there's enough reason to say it is so, that the initiative that AFSA and SARIPA have taken and the movement towards institutionalizing business arbitration as a dispute resolution mechanism in business rescue proceedings is certainly something that has been a positive step taken in the context of business rescue. It's now up to us to take that step further and further and further so that we improve along the way. But that's where we're at the moment. And it's an arena which is exciting. It's an arena which offers many opportunities. And it's an arena which we need to focus on, and in doing so, change our habits as litigators so that we can litigate in that arena in a manner which gives effect to business rescue. Thank you, Lizelle.
Thanks, Azhar. Azhar, I think that is, of course, the initiative was one of the reasons why it got off the ground. Was Chapter 6 makes provision for a specialist court, which the initiative is certainly not aimed to oust the court's jurisdictions on any of the issues, but the rules in particular, which Colin will talk to in a minute, is specifically there for speedy resolution. And because it is the people the retired judges who are on the panel, who understands the law. I mean, if you look at, I think Fritz Brunt is sitting as one of them. He wrote the first judgment in the SCA relating to business rescue. It's people who understand and know. And it's for that reason that people who know and understand and appreciate the value of a speedy resolution, that this forum and the initiative was geared towards. The other thing which is striking for me, which you've mentioned, and I would like to hear Colin on this, and I'm sure he will touch on it, is utilizing this. Of course, you can't force someone to do it, but try and utilize it and get agreement pre-adoption of the plan already, to utilize the rules and the forum to get some of the disputes already resolved before even the adoption of the plan. I think will go a very, very long way if one can achieve that, all in good time. Colin, on that score, if you could give us a rundown practically on the rules of the forum, and in particular in relation to achieving what Azhar said, perhaps pre-rescue if that's already appropriate, and then of course post adoption. And if you've got, I think you do have one or two examples, as Azhar has mentioned, which is very exciting for everyone, and hopefully we can start building some form of a authorities bank in the forum in months to come. Thank you, Colin. Over to you.
Thanks so much, Lizelle, and thank you, Azhar. As Azhar has articulated, clearly the advantages that are open to all potential litigants in business rescue proceedings are the expedited, fair, and cost-effective method of resolving disputes. Lizelle asked me to address briefly how you do this before the adoption of the plan, because really the adoption of the rules can only effectively take place by agreement. And once the plan is adopted, there's the statutory agreement that's created between all parties. So how do you achieve that before the plan is adopted? Well, the only way you can really do it is to meet with the other side, agree the process, agree the rules, and then just approach AFSA and the Secretariat of AFSA and implement the rules. They're very easy to read, very easy to follow. In fact, that's one of the biggest advantages of these rules. They are simple, they are short, they cater for all difficulties that we as litigants have encountered in arbitration, such as interruption of prescription, joinder of interested parties, resolving of interlocutory applications, removal of arbitrators at a point where it becomes necessary to remove them, powers of arbitrators, all kinds of difficulties that we encounter have been catered for briefly and in a very, very easy to follow process. So I'll take you through that process, but first let me come to the how. How do you, in your business rescue plan, bring about a binding agreement which binds the BRP and, of course, all parties who has disputes with the BRP and vice versa to use these rules in the AFSA SARIPA forum for the resolution of your disputes? Well, it's quite simple. We've devised a few set of clauses which should be adopted into the business rescue plan. Very short. One is the definition of claims. So you just take out your old definition and put in the new one. The other is the definition of creditors, which also caters for trusts who are disputing claims or have any other disputes with the BRP. You insert that clause, and then you just put in a very simple clause which tells you in a paragraph that any dispute of whatsoever nature which relates to the acceptance or rejection of claims or the acceptance or rejection of security or the recognition of security, anything to do with claims and security, claims which we often find are not reflected in the books and records of a company that's in rescue, and the claimant wants to enforce his claims, it deals with such a claim as well. It also goes very much further, and it allows for acts or omissions by a business rescue practitioner which affects the legal rights of affected parties and the legal interests of affected parties. That is so wide, and it can deal with just about any dispute that arises at any stage from adoption of the plan onwards, and it affects the rights of any affected party. And it also allows for disputes regarding the proper interpretation or implementation of any provision in the business rescue plan. So it caters for almost everything that could arise and that could delay and in fact derail a business rescue when there's a dispute that deals with any of those aspects. So that's how you bring it about. You adopt our standard clauses, you put them into your business rescue plan, and then you attach a set of our rules, which is only a few pages, very short rules, and as I've said, very simple to follow. So in a nutshell, once the plan's adopted and when a dispute arises, whether it's at the instance of the business rescue practitioner as the claimant or a creditor or anybody who has an interest, you write to the Secretariat, you adopt a form which is attached to the rules, which you fill in, very simple, set out the nature of your dispute, pay a deposit of 15,000 Rand, and the Secretariat then determines whether it fits within the ambit of the dispute resolution clause as in the adopted business rescue plan, and is happy you've paid your fee. She then accepts the claim. And the importance of that is that's when the prescription or the interruption of prescription commences to run. So once she receives it and she adopts it, then the date that she received it retrospectively, once she adopts it, is the date that prescription is interrupted. And that's very handy and very practical, as litigants will know. She then sends it off to the business rescue practitioner, and he has to fill in a form himself dealing with the claim, and he also has to pay a 15,000 Rand deposit, and those costs cover the costs of the Secretariat in administering, in effect acting as the registrar does in a high court, administering the file and taking an active role ensuring that the parties stick to time limits and ensuring that the BRP is paid and that the amounts that the BRP budgets for his fees are collected and held and is paid by the Secretariat. So for that role, the 15,000 Rand received from the claimant, if it's not the BRP, and the 15,000 Rand received from the BRP covers those costs. Then at this point, the parties can agree to go to mediation, and Duncan will address you on how that is brought about. Alternatively, if the Secretariat thinks it's a simple issue which requires an intervention of a mediator, which appears could bring about a very speedy resolution, she can also then make the necessary arrangements for mediation, and she will appoint a mediator. And then the matter goes to mediation, and as you know, mediation is not binding until an agreement of settlement is concluded. So if the mediation fails, then you're back to the arbitration. Then the parties can select their own arbitrator, and if they don't, the Secretariat will, as is normal with arbitrations where no arbitrator has been appointed, will nominate then an arbitrator, and then the arbitrator accepts his appointment, and the arbitrator then brings about an initial meeting. And the rules then specify that the arbitrator, with his experience, will then at the initial meeting determine how the arbitration is going to unfold procedurally. He obviously is under an obligation to ensure that the arbitration is expedited in a fair fashion and in a cost-effective fashion. And in doing so, he will decide whether oral evidence needs to be led, whether the issues are purely legal and can be resolved on the basis of legal argument only, or if he feels that the pleadings need to be brought about and the issues elaborated on or more crystallized, then he will specify exactly how he believes this arbitration should unfold, and the rules cater for this quite aptly. Once the procedures have been agreed, then the arbitration commences, and the arbitrator is to give his ruling 30 days after, whether it's argument only after the arguments have completed, or 30 days after the arbitration proceedings have finalized. The arbitrator's powers are also quite wide in this matter. Now, I did tell you that these rules cater for difficulties that one encounters in arbitration. One of those is when one of the parties doesn't pay his way, where the party doesn't put up their money to pay for his share of the arbitrator's fees. These rules cater for it quite adequately, and in that regard, the arbitration can proceed in the absence of the other party to finality, and the arbitrator can also, where a party is being obstructive, doesn't do what's been ordered, etc., put that person or that party on terms, and if they fail to comply with the terms, proceed in the absence of that party or penalize them on costs. So this is an innovative rule and a very, very handy rule. So that's part of what the arbitrator's powers are. The arbitrator also has the powers to determine his own jurisdiction. And a new innovation which we've introduced into the rules is settlement agreements. You know that when you have an arbitration and the parties reach a settlement, how do you bring about that settlement? So we've provided for the arbitrator to have the power to make settlement agreements an award as if he had made the award at the conclusion of the arbitration proceedings. So another very, very handy part of these rules, which eliminates the difficulty that parties have when they do reach settlement, which is very often in arbitration proceedings. The rules also cater for security for costs, both for the claimant and the counterclaim claimant. It deals with the expedition of interlocutory applications such as discovery, additional discovery, all these type of applications which seem to slow down a process. There's a very expedited procedure which the arbitrator brings about in resolving these issues, interlocutory issues under these rules. And that's really it. It's as simple as that. It's as convenient as that. It's as practical as that. And it's really something that we would recommend all arbitrators use, because it gives effect, as Azhar has painted the picture, to the expedited resolution of disputes, which in many arbitrations in many rescues derail the rescue and actually lead to liquidations of the company. So if you haven't yet used them, please use them. Please use our standard clauses in the plans that you have, that you're drawing or you've got coming down the line. Simple clauses, attach the rules, and hopefully you'll see what an easy and I think brilliant method has been employed to bring about a resolution of disputes in business rescue scenarios. That's me, Lizelle. Thank you.
Sorry, not so fast yet. I've got a couple of questions, and I think there are some questions in the question box as well. Colin, all of this, I think there's no doubt that the rules cater for the effectiveness, practicalities surrounding the resolution. And I'm going to play a little bit of devil's advocate for the small to medium business rescues. From a cost-effective perspective, is it cost-effective? I know one shouldn't be penny wise to be pound foolish, but I think there's some thought or some question in some people's mind as to, if I've got a 100,000, 200,000, R500,000 claim, is it really worth my while to go this route? If you've got an answer, otherwise everyone will be referred to the rules, but maybe you've got a comment on that.
Costs are obviously very important in every litigation dispute. I suppose that's the first thing one has to address right up front, because litigation, and of course arbitration is a form of litigation, is expensive. So if the amount involved doesn't warrant litigation, doesn't warrant arbitration, then I would discourage it, and the party should get together somehow and try and resolve it. Alternatively, without applying to the Secretariat to administer it, approach mediation, approach Duncan's mediation group and go to mediation and resolve it in that fashion. You can do it without attorneys, and you can do it in a cost-effective manner. But certainly I would discourage claims which are in the region as you've described, or even less, not to go this route.
Yeah. Colin, then you've mentioned that the rules provide for the Secretariat, for the parties to appoint an arbitrator, failing which the Secretariat will appoint the arbitrator. It's linked to a question by Keith Bradford as well, that firstly, in terms of the rules, are the parties prescribed for who they are allowed to use if they, by their own agreement, elect and appoint an arbitrator? Firstly, and then secondly, Keith's question is, Is there room or a plan to involve retired attorneys who's got expertise in this field in months to come to maybe form part of that panel?
You have to use the approved panel if you approach the Secretariat and follow that route, but you can choose the arbitrator off the approved panel yourself as parties in the normal course. If they don't, then the Secretariat will appoint the arbitrator. The panel comprises upfront now retired judges, a lot of them from the SCA, and those judges who have been involved in judgments where business rescue and the interpretation of Chapter 6 features. So we've really been selective. We would like this, let's call it court for want of a better word, this AFSA SARIPA court, which deals with business rescue, to have credibility, to start off on a sound, commercially sound ground. And that's why we've selected upfront these judges to sit on the panel. There will be development later down the line. It's too soon now, but there is plans afoot later on to even use business rescue practitioners who have experience to deal with these disputes. Attorneys, of course, as I know Keith is a member of our sidebar. So it will bring in people who have experience in rescue and who, it is felt, have the necessary expertise to resolve disputes, to be able to sit on the panel. But that's at a much future date.
Thanks, Colin. Two more, perhaps. Christelle Kiwi, there's a question or a remark relating to assets, in particular those secured by lenders or other creditors who immediately upon commencement of rescue cancel lease agreements, or perhaps I would imagine vehicle asset finance agreements, etc. And she says this leaves not much of the necessary breathing space to even get to the publication of a plan and then adopt the rules in order to go and dispute and resolve any dispute in relation to that. And her question is, can AFSA also assist BRPs in these matters or not? Now, before you answer, I think we just legally there's authority whether or not those lenders or secured creditors are entitled to do that. So, I mean, if they are entitled to do it, then the law, I think, at this stage, in some instances, are pretty settled. That being said, and Colin, correct me if I'm wrong, pre-business rescue or pre-adoption of the plan is exactly what you mentioned right at the outset. There's nothing that prevents the BRP to propose to this specific creditor or class or group of creditors to say, listen up, we can't have this. I dispute that you're entitled to do A, B, and C. We don't have time to go to court or to go to anything else. SARIPA, AFSA rules are there specifically geared for an expedited, practical resolution of these disputes. Please, can we agree in the manner which you've explained right at the outset to refer this to AFSA, adopt its rules, and then it's a short agreement by which the parties then bind themselves and say we agree on this type of resolution.
You've answered the question perfectly. Thank you, Lizelle. Obviously, the moratorium has been whittled down slightly, and this is one of the exceptions to the moratorium.
Yeah.
Those who have lease agreements and who can cancel and then take the asset, which
because
is
it's not enforcement action.
But of course, the parties who are involved in a dispute, and certainly where it appears that there's a huge value involved in the amount, and where they need an expedited resolution, to meet, agree to, instead of going to court, where obviously they're entitled to go and maybe get delayed in the system, approach the Secretariat, AFSA, and embark upon the arbitration as set out in the rules that we've devised. And I probably recommend it because, as you know, you do want a speedy resolution of all disputes in rescue, and you don't want to derail the rescue proceeding because of one dispute. So I think the best and probably only choice you have is then to follow the AFSA SARIPA dispute resolution proceedings, and that should bring about speedy, fair, and cost-effective resolution for you of that dispute.
Colin, and then lastly, for now at least, Philip Reynolds asks, and I actually don't know this answer, if there's provision in the rules for confidentiality, because he asks if the determinations will somewhat be reported to the professionals and to the profession to develop some form of a precedent. And I don't know if there's a confidentiality provision in our rules.
Always an excellent question from Philip. Thank you.
Put him on the spot, Philip.
Arbitrations are by their very nature confidential. So yes, it is confidential. This has come up regularly in our discussions with Michael Cooper and his team, and Azhar representing AFSA at the time, and myself and our team, Davy van der Merwe, Renee, all of us representing SARIPA. So yes, the proceedings are confidential. The parties can waive it. We'd like, and that is one of the reasons that we chose the panel that we have to kick off with, we'd like to create a precedent bank of all matters that come before SARIPA. But we do appreciate that matters are confidential, and you don't want to publish judgments that are confidential. So with each party's consent, either they'll waive the confidentiality or they will allow us to publish after redacting their names. So yes, it's confidential. We will preserve confidentiality. If it's a good judgment dealing with an interpretation of the rules which we've all been waiting for and has a practical benefit to the profession, we'll approach the parties to either get them to waive the right and allow us to publish, or to publish with their names redacted.
Thank you, Colin. You're off the hook for now. And then Duncan, you are probably, for me, for today, the most exciting part of this. And I see that please don't feel that you need to rush this. I said at the outset, I think mediation is probably the least utilized tool, which could be one of the most effective tools to resolve disputes. And the field of business rescue is no different. So I would love to hear from you how you think we can all be better to resolve issues through mediation. Thank you.
Thanks, Lizelle. Good afternoon, everyone. So just a little bit of background. I am a hardened litigator. I have 25 years of litigation. So when I speak to you now, I don't speak with a soft hand. What I do speak to you with is a very realistic view of how disputes arise, why disputes continue, and how disputes are ultimately resolved normally. And I think that if I start at the back, disputes are normally resolved through a settlement. We litigate, we arbitrate, and you will find that more than half, and sometimes in some cases 80–90% of cases, will get to the doors of court and will settle. Now, if that is the ultimate result that we achieve through this litigation approach that we have, that means that settlement can be achieved at any stage of that process. Now, there may be various reasons why it's not reached earlier. But the idea that many legal practitioners will say, well, these parties hate each other, or these are intractable disputes, these are far too complicated disputes, could never settle them. Those kinds of reasons just don't wash, because those same disputes are the ones that will settle the day before court, or on the first day of court, or the week before court. So that sort of principled reaction that so many legal practitioners will give you just shouldn't be accepted. What we need to recognize is that disputes arise because people don't have another option. That's, in other words, disputes continue because people don't have another option. And so what you need to sit back and think about is, do I have other options? And if I have other options, what are they? And how do I find out what they are? And And again, the exploration of options is not something you can do unilaterally. You can't sit in your own room and work out what the options are for the resolution of the dispute. Because when you're in a dispute with two or more parties, everybody's got to understand all the options so that they can all explore them and see if they can find a common solution. And what happens and why disputes continue to the point at which they are ultimately resolved is because people don't get in a room. People don't sit down and work out where the common ground might be, where they might find a common solution, or where they might just see the writing on the wall for the first time. Because when you sit in your own room with your own attorney and your own advisors and your own family, nobody's going to be writing on the wall. You're all telling yourselves your same story, and you all just entrench your own beliefs. And so the continuation of a dispute arises because there hasn't been an objective, very, very often, there hasn't been an objective perspective brought to the dispute. Now, we often find seasoned lawyers who will say, well, if I can't negotiate the settlement with the other side, and I've got 25 years of experience, what's the point of appointing a mediator? Clearly, they're not going to do anything better than me. But the reality is that that lawyer is as subjective and biased as anybody, as the party. Very often, the lawyer has to be committed to their client's case. They have to give their client the support. They have to seem to be the soldier on their client's army. And from that perspective, you cannot bring objectivity to the case, number one. And number two, even when you engage with the other side, you are engaging as opponents. And so the level of trust in the room is almost zero. Where you are engaging in a bona fide engagement, there has to be a level of trust in the parties, and if not in the parties, in the process. And where the process is set by two parties negotiating bilaterally, the level of trust is very low. So when you see that disputes arise because there's a difference, and very often that difference gives rise to a rational belief that I'm right and you're wrong, or an emotional belief that I'm right and you're wrong, it really doesn't matter. Whether you're legally right or emotionally right, doesn't matter. If you feel you're right and the other person feels they're right, you're going to have a continued dispute. And so the question is, what process can you adopt to bring perspective to your dispute and see if you can find a result? Now, the traditional process is an adversarial process. Through that adversarial process, somebody will put their position, have it attacked by the other side will put their position, have it attacked by this side, and then the writing will be on the wall. And the arbitrator or the judge will read the writing on the wall to the parties, will write it in a judgment and hand it down. That's how the writing gets on the wall. So you are you're asking the question, well, can we get the writing on the wall earlier? How do we get it there? And mediation is a real tool, because what mediation does is it creates, if it's done properly, and I qualify that because there are a lot of people out there who hold themselves out as mediators, but they don't do it properly. And so people come out of that process very disappointed. Either the person has tried to bully them into a result, or the person has been so standoffish that they haven't been able to move. So there are very important techniques, training, experience in the process of managing mediation that need to be employed when you are trying to mediate an outcome. And with the greatest of respect, senior lawyers who are senior litigators make terrible mediators if they're not trained, because they are trained, and I'll tell you now what the difference is, but they are trained in identifying right and wrong. And so they're trained in identifying the legal rights which attach to a problem and to trying to deliver a legal solution to legal rights. And mediation does something completely different. Mediation says legal rights exist, but I'm not looking backwards to do a forensic exercise and determine who's right and wrong. I'm looking forward to determine what the interests of the parties are prospectively and to see if I can find common ground in their interests. Now, their interests obviously will develop from their rights. We need to there's a level of understanding. Where do you come from? What happened? Who contends what? But having some idea of what's happened allows you to project forward and look into prospectively what parties' interests, how parties' interests can align. And a well-trained mediator will be able to, number one, bring a process to bear on the resolution, on the engagement with the dispute. So the process is critical, because if the parties trust the process, they can look to find solutions. The other thing the mediator brings is neutrality, impartiality, and hopefully experience and expertise, because that develops trust too. The parties then trust the person's expertise, and they trust the mediator's neutrality and independence. And if the mediator engages as they should, the parties will see that the mediator is committed to finding a win-win solution. And they will go on that exploratory journey with the mediator. So we just think about the ability of two parties who hate each other sitting in a room, and then think about the two parties sitting in different rooms explaining their problem to an independent third party, so that the independent third party can get an objective view of the two differences and then try and find ways to create a solution. The analogy that many of the textbooks use is to think about yourself as a observer in the Arctic Sea, and you come across two icebergs. From the position on the deck, you're looking at an iceberg on the right and an iceberg on the left, and there's this massive expanse of sea between them. Those are the positions of the two parties. And to the observer above the water, there's just no way those positions could ever reconcile. They're separated by this vast expanse of water. And if you imagine the water as being the level of information that is available to the observer, and what the parties do is they sit on their separate positions and they fight over the water, but they fight from their respective positions. What the mediator does is the mediator is allowed to look under the water on the one side and look under the water on the other side. And if anybody knows anything about icebergs, the body of the iceberg under the water is something like 7 or 10 times bigger than the body above the water. And what you find is this iceberg and this iceberg actually coincide under the water. But neither will see it if they're sitting in their respective positions above the water. So that's what mediation brings as a process. And if you have the right mediator who manages the process correctly, you can, and the success rates are phenomenal. In the English, the CEDA, the main body in the UK, they reckon 80 to 90% of commercial disputes are settled either during the mediation or within a month afterwards. Very often the parties need to sort of consider what they heard at the mediation before they'll settle. But that process, basically they read the writing on the wall, but they weren't ready to accept it in the mediation. But that writing on the wall stayed with them and they settled it afterwards. So the benefit of a mediated outcome lies in a couple of big things. The first is the mediator. You need the right expertise and experience in the mediator. The second thing you need is an authorized person to resolve the conflict. Now, in a BRP, in a business rescue, you're going to have various parties. As I mentioned them earlier, you can have employees, creditors, the business rescue practitioner. You can have all sorts of people that might have an interest in an outcome. The mediation can facilitate that with all of them. You can have all of those people involved in a mediation where the mediator either brings them together, shuttles between them, and works out where the common ground is and where the solutions might lie. And as Azhar said as well, everybody in this process ought to be committed to making the process work, because everybody loses if the process fails. And so if you think about interests being your interest in a successful outcome to the business rescue, your interest, rather than your right, which is a forensic exercise into the past, you can then realize that you actually don't need an answer to your right, as long as you can find a solution to your interest. And it's something that lawyers are very, very bad at. Litigation lawyers are terribly bad, because we believe that you can only have a solution after you've got an answer. So you've got to go through the legal process to find out what the answer is, and then I can give you a solution. Mediation doesn't work. Life doesn't work like that. Very often we never get answers. We just got to move on. And mediation's the same. You've got a process where the mediator makes the parties realize you actually don't need an answer to get a solution. And the solution you get is a solution you'll agree to, because the result of a mediation is a settlement agreement. So it's a consensual agreement that remains within the power of the parties to determine. I can throw a couple of sort of buzzwords at you and talk about facilitative mediation and evaluative mediation. But the reality is you need a mediator who can come along with sufficient expertise to test a party's version without giving their opinion. The mediator is not going to come in and say, I think A is right and B is wrong. That's not going to work. If you do that, you lose parties. They don't trust the process. But what you can do is bring someone in who understands the problem and is able to say, but have you thought of this? What happens if that happens? What happens if the evidence is this and not that? And that realization, people haven't been tested. That realization then dawns on them. The other thing it allows people to do is have an emotional outburst. Now, as silly as it sounds, it's incredible how it works. A person may be so angry that they haven't been able to see any reason. A mediation allows them to have their day in court. They can sit with a third party and engage with the person who's made them so upset in a safe space. And it's incredible that once that emotional outburst has happened, they can carry on with life and find a solution. But they have to be given that opportunity, and mediation often gives them that opportunity. So there are various techniques, both from a technical approach, from a psychological approach, financial approach, that can be brought to bear in a mediation. And what you must always remember is that a mediation can give you solutions that you can't get in any other process. When you go to court, the lawyer will tell you, if the problem is this, the relief you're allowed is that. That's the only relief you can get. If you're claiming payment, you get payment. If you want specific performance, you get specific performance. And arbitrations work the same, because that's how the law works. There is a set of remedies that are available for a particular problem. Mediation is very different. Very often, the solution that you get is unrelated to the problem. I'll give you just a simple example. I had a case with a service provider who was an educator, and they were teaching agricultural products, and they had to build a greenhouse. And they weren't builders of greenhouses, so they hired a contractor to build the greenhouse for the client, and the greenhouse fell over. So the client sued the educator for the greenhouse because the greenhouse had cost money and it hadn't worked. The educator didn't have the money, had a huge problem. But the client was a big corporate industrial who had corporate social responsibility obligations. And their solution could have been to liquidate the educator, take 5 cents in the rand or whatever they could get, or come to mediation and get the educator to provide education services to their employees and the local communities around their business at reduced rates. So the educator continues their business. The mining house gets a solution to their CSD problem, and the local community gets the benefit of both. Now, no arbitrator can award that. So you need to be able to think out of the box, and you can find incredible solutions through mediation. Now, just bringing it back to the BRP, is that's what a BRP is looking for. They're looking for limited costs, limited time, and a solution that they can implement that may or may not be related to the problem. And that would be solutions that would be useful to employees, to creditors, whatever. But the flexibility of the mediation process allows for those kinds of inquiries where the traditional litigation and mediation process doesn't. So I think my time's pretty much up, but just one other thing, just to go back to the rules that Colin referred to. The mediation provision in the SARIPA rules is very well positioned. What the mistake that so many people make is that they will take the mediation process and put it at the very beginning of the process, before the parties have exchanged their pleadings or their position statements or their statements of claim. And the problem with that is people don't have enough information to know what the problem is. And so they go into a mediation without really understanding the problem. And what the SARIPA rules do so well is they say mediation comes after the parties have exchanged their positions. Once the claimant has put their position in, the respondent has put their in, the issue has developed and crystallized, and then you go to the mediator. Because then that exploratory element has been resolved and people understand what the problem is, and then they can try and solve it. So, Lizelle, I know we're short on, I just don't want to overstay my time, but yeah, I'm looking at my notes here and just saying there are so many different benefits to the mediation process. But let me just leave you with 2 things that you can write down. The one is the BATNA, your BATNA, and your WATNA, WATNA. And I could leave it there and make you go and research it. But what it means is it's your best alternative to a negotiated agreement and your worst alternative to a negotiated agreement. What that means is when you're sitting and you've got a dispute and you say to yourself, I could go through a negotiation or a mediation and get an agreement, which allows me to move on with my life, or there's an alternative. I could win a court case or lose a court case. My best alternative, my worst alternative. But there may be various others. I might lose management time. I might lose employees. I might lose. What are the alternatives? That if you don't negotiate an outcome, what is your best alternative and what is your worst? And very often, your worst is significantly worse than you thought it was, and your best isn't that much better than a negotiated outcome. But until you've done that analysis, and with the assistance of an objective outsider, very often you haven't reconciled in your head how you need to resolve this dispute. So I would recommend mediation, and I would recommend the AFSA team, because at AFSA we're developing a panel that will have the necessary expertise and the process to take these things forward.
Duncan, thank you. I had no doubt that this is, for me, going to be the most interesting part, and it certainly did not disappoint. I think it's absolutely, in my mind, the most underutilized tool. It's interesting to me that the purpose of what you can achieve through a mediation is, I think, exactly what business rescue practitioners or any other stakeholder in BR struggles with most right at the outset, and that's that trust and that disgruntledness and the uncertainty of what's going to happen, where if you get a third party in objectively telling you, listen up, we can look backwards, but that's not where we're going. Look forward. We all want to continue with business. You want to continue with business. I want to continue with my business. Let's look forward and get a solution. For me, that is right in the center of any business rescue. And then so often where a mindset, I think, goes wrong is mediation is not a round table. It's not a round table between parties where each one brings their own lawyers to the room and we fight it out and see if we can find a settlement. And I think that is sometimes where we forget that mediation is not a round table. It's not a negotiation to try and reach some form of a forced settlement into things. It's exactly as you say. We look at the two parts and we see what is at the end of this, what is my best, what is my worst. And can I rather look forward than looking backwards and whipping the rights that I so feel that it's owed to me. No winners or losers all the time. And then if at the end of the day you can't mediate or find a solution, then you can go and litigate and get your day in court. But it's interesting to me that you say what the statistics also show, what the value add and the positive results is that mediation brings about. It's incredibly positive and encouraging. I do think that we've reached the end of our discussion. I think all of us can probably go on and talk for as long as we want. Colin and Azhar, if you guys are still there, I just want to thank you as well, Colin, Azhar. Duncan, thank you very, very much. It's certainly been educational. It helped me in my mind also to understand the different aspects, the practicalities in relation to the rules itself. I hope everyone else has enjoyed it. If you've got any questions, you won't be able to put it on the screen anymore, but certainly if you want to contact the SARIPA office, AFSA office, or any of us on the panel, you are more than welcome to do that. Again, to my panel, you are phenomenal, incredible. Thank you very much for your time and efforts, and we'll chat soon. Have a lovely evening, everyone.
Thanks, Lizelle.
Thank you, Lizelle. Thank you very much.